This case starts wild, a drug grow operation, right inside a baby's crib. That's not a typo. When police found controlled substances where an infant slept, everything changed. Today, Judge Boyd-style precision meets parental negligence. We're talking multiple indictments, deferred adjudication deals, and a defense that's hanging by threads of rehabilitation. Stay tuned, this one gets messy fast.
Enrique Jariguay? Yes. All right, Jacob Aguero?
Ready.
And are these applications?
Their recommendations.
All right, court is calling 2025 CR 0099798 and 2025 CR 007562C, State versus Jacob Aguero. Could I have parties announce?
Jason Gear here for the state, Your Honor.
Suzanne Kramer for Mr. O'Carroll.
And are you Mr. Aguero?
Yes, ma'am.
Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
I did, Judge.
In each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Aguero, in each of the cause numbers, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
And Judge, in one of the cases, it's a waiver.
Okay, just one second.
That would be the case ending in 798, Your Honor. Rick Pena for the record.
Okay, thank you. All right, so then the record is clear. In cause number 2025 CR 007562C, did you review the true bill of indictment in that case?
Yes, Your Honor.
And with your attorney, and did you understand it?
Yes, Your Honor.
And state, in that case, are you proceeding on the indictment as presented?
We're waiting count 2, proceeding on count 1 alone.
No objection, Judge.
And in that cause number as well, the court will find that the state is in compliance with discovery. And the cause number. All right, and there's no W in the other cause number?
And I mentioned that to my client, that maybe that's just some new Odyssey thing and there's no W anymore. There's no more. Okay.
Yeah, the clerk informed me they don't put W's at the end anymore.
All right.
I asked the same thing just a second.
All right, Mr. Aguero, did you review the waiver of indictment reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did
I
you
did, Your Honor.
understand it? And did you sign it?
Yes, ma'am.
You have a right to have your attorney, well, first, you have a right to be indicted by a grand jury. And they would hear whatever evidence is presented to them and make a decision on whether or not you should be held over for trial. Your attorney has certain rights. They have the right to have 3 entire days pass, and they also have the right to have 10 days pass to prepare for trial. Did you understand?
Yes, ma'am.
By entering this agreement, you're giving up those rights. That you intend to give up those rights?
Yes, ma'am.
All right, the court will find that defendant has knowingly and voluntarily waived indictment reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In that cause number, did you review the information?
Yes.
All right, and counsel, do you waive the reading of the information?
I do, Judge.
State you're proceeding on it as presented.
Yes, Your Honor.
Right, in each of these cause numbers, you've entered a application for deferred adjudication or community supervision, and you reviewed that with your attorney
Yes, Your Honor.
and you signed it?
Yes, Your Honor.
All right. In each of the cause numbers, did you review the court admonishments?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
In the cause number ending in the letter C, the state is proceeding with manufacturing, delivery, and controlled substance penalty.
Here's where things get technical. The judge is explaining deferred adjudication, basically a legal second chance. If Jacob follows every term, community service, fines, parenting classes, his record could stay clean. But one slip up, and the deal collapses. He could face life in prison for the manufacturing charge alone. What's striking is how calm he stays while the court outlines decades of potential time. Think about that, standing there, knowing that your freedom depends entirely on future behavior. Would you be able to keep your composure?
Group 2, 4 to 400 grams. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If the court grants your application for deferred adjudication, if for any reason your deferred adjudication is revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine. In the cause number ending in 8, the state is charging you with abandonment or in danger of a child, criminal negligence as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
In each of the cause numbers, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering into these plea bargain agreements, you're giving up those rights. Did you intend to give up those rights and enter into pleas in each of these cause numbers?
I did, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has to.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
In each cause number, sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
They have not, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, according to the plea bargain agreement, there's to be a fine in one of $2,000. The other fine is $1,500. The cases were run concurrently. The state is recommending deferred adjudication, and there's to be restitution of $380 to the Bexar County Crime Lab for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State? Did you review the waiver of appeal paragraph in each paragraph? Did you understand it and sign it in both places?
I did, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I did, Your Honor.
Counsel, are there any such motions? Outside the agreement and the cause number ending in C, the state is recommending that your community supervision be for a term of 6 years. There be 200 hours of community service restitution, the MRT, and life skills course. And the cause number ending in 8, there's to be 2 years of community service restitution, 100 hours community service restitution, no contact with Layla Aguero, parenting classes, TAP evaluation, follow all recommendations in the MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
All right, then in cause number ending in 9-8, how do you plea?
Oh, I just wanted to clarify that we were going, no agreement on the Layla, no contact order.
All right, then in cause number 9-8, how do you plead? Guilty, not guilty, or no contest?
No contest?
And in cause number ending in C, how do you plead to count 2, guilty, not guilty, or no contest?
No contest.
State any evidence.
In both of the cases, state exhibit number 1 with all the statutes.
Any objection?
No, Judge.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, each cause number after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
I'm very happy with the plea bargain. I think that both sides were very fair. I'm just, the Layla is only 3. And the CPS case that was open when all this happened has been cleared. He had to take some parenting classes. He got custody back. They never took her away. So that's all good. So, and I, had a nice long talk with him about not making this kind of fairly kind of stupid mistake again.
It was.
And so we just want the no harmful instead of no contact with Layla.
All right, I don't know about that. And let me just tell you why I don't know about that. One, I don't know what works.
And there it is, the judge drops the hammer. She's not buying the CPS cleared it argument. You can feel her frustration, drugs grown near a baby's crib. That's not just bad judgment, it's moral failure. Notice her tone shift, she's less focused on punishment now, more on protecting the child. This isn't about law anymore, it's about humanity. The defense argues for a no harmful contact order, but the judge pushes back, because how do you prove a parent like that has truly changed? Real question, if CPS closed the case, should the court still step in? Drop your take in the comments.
CPS did. There's an issue if you have drugs and the growing of drugs, and there's a baby crib where the drugs are being grown, and you have children who live at your house, but you disregarding that. A child can't say, hey, Dad, I don't want you growing drugs in my room. I don't want you growing drugs in my house. And that's where we are. And I don't know what kind of work CPS did.
Well, and the thing that I'm concerned about, Judge, is Kelly, the mother of this child, is also charged. Now, I don't know if they charged her with child endangerment, but she certainly was there. She's charged with the drug aspect of this. So you do a no contact on the parents.
Well, there's going to be no contact with him.
Well, but she lives with him, the mother, and the mother is charged with, except for the child endangerment, but she was charged. I don't think she was charged with child. She was same exact thing as him. So if you take, no contact on him, it's no contact on her, and then the kid.
Well, I don't know what I'm going to do about mom, but what I'm doing with this case is there's no contact with Layla Aguero. Now, if y'all want to wait and have sentencing at another date, we can have sentencing at another date, and you can have Child Protective Services come in and explain to me what he has done.
Well, I know that Kelly is in the lineup to plead today, so we could wait to see what you're going to. I mean, it seems it wouldn't be fair to, say, okay, well, she can.
Well, all cases are individual. I mean, I treat everybody as an individual. I don't understand why CPS would return a child to somebody who's growing drugs in the child's room. But I don't know what CPS did. Sometimes CPS will, as you know, counsel, sometimes CPS will dismiss cases. And the reason why they dismiss and close cases is because one parent did the service plan, the other didn't. I don't know if he did his service plan or not. I don't know if they had a family-based service plan. I don't know what happened. So what I can do is I can take his plea now. And then if somebody wants to get the court some information or documentation from CPS, then I'll look at that.
All right, let me talk to him.
In the end, the judge holds firm, no contact with the child, at least until she hears from CPS directly. It's a sobering close to a case that blurs the line between rehabilitation and recklessness. Deferred adjudication gives Jacob a shot at redemption, but the message is clear, the courtroom won't gamble with a child's safety. If you found this case as shocking as we did, hit that like button, drop your thoughts below, and subscribe for more real courtroom breakdowns, where every decision has a story behind it.